The fight for freedom begins. Attorneys on Retainer Association takes on the Commerce Clause in the 10th Circuit. We got the full breakdown. Stay tuned. This is attorneys Andy Marcantel and Marc J. Victor. We're the partners at the Attorneys for Freedom law firm here today to talk about our first case for the Attorneys on Retainer Association. How you doing, Marc?
Dude, first one. I'm super pumped up. This is the kind of stuff you want to do when you're sitting in law school and you're listening to the horror that is the con law class, right? And you're thinking, wow, look how our country was set up to be so pro-freedom. And then you read the cases and you see, what happened? How did we go from this very limited government to this big behemoth federal government that gets to do everything? And you sit there and say, I want to do something about this. And then you become a lawyer and you got to make a living and you just can't, who can do this kind of stuff?
Yeah, it's really exciting. I was talking to my wife about this case and how excited I am. She can always tell when I'm really excited for a filing. And I was actually reminiscing about a couple of things. I don't know if you remember this, Marc, but you and I have been working together for well over a decade now. And I remember when we first met, I was a little whippersnapper, fresh out of law school, and I had just been giving my con law professors headaches over the Commerce Clause. I couldn't believe what I was hearing when they were talking about this expansion over the decades of the Commerce Clause at the expense of Americans' freedom at every turn. And I remember when you and I met, we went to lunch. It was maybe our second or third lunch we ever went to, and the Commerce Clause issue came up, and I was so happy to know you're just as pissed off about it as I am.
Yeah, most people don't get excited about talking about the Commerce Clause, but it's something
I don't know why not.
I don't know. I mean, I've been crowing about this thing, since literally when I started law school in, dare I say, 1992, and I tell people about it, and it just don't seem to get as fired up. So hopefully we can get people fired up.
Let's start with that. Let's start with why people should care about what we're up to here with this amicus brief we filed.
All right, look, you have to remember, the Founding Fathers, they fought what could be described as a treasonous war against their own government, right? These people were committing treason.
Traitors one and all.
Absolutely.
Traitors to the crown.
They said, enough with King George III. We're going to send him this big declaration of independence and tell him, look, I know you think you own this property over here in the 13 colonies, but you don't anymore. We're taking it from you. We're sovereign, and we're willing to fight about it. And, John Hancock, the short guy, comes in and signs this big, huge signature.
Was he making up for something, perhaps?
I don't know, man. But reportedly, he says, I want to make sure King George can see that my signature, John Hancock, is here to think about the kind of guts it takes to sign a document and send it to what is at the time the superpower of the world and say, come do something about it. And of course they did. People forget, but for France teaming up with us, we probably lose the Revolutionary War. And then all of a sudden, we don't start with the Constitution. We start with the Articles of Confederation, this very loose association between the various colonies, the states, if you will. And some people say it works pretty well, and some people say it doesn't. And there's a lot of dead around after the Revolutionary War. In what some people describe as a counter-revolution, right? The Constitution is now proposed. People are like, look, we just fought off a strong central government, right? We don't need to now turn around and set up a big, strong central government. Well, the argument from at the time, the Federalists against the Anti-Federalists. A lot of people don't know. They hear about the Federalists and the Federalist Papers. There's an equally large body of writing out there by the Anti-Federalists, who are essentially the group of people who said, you know what? We're not in favor of this Constitution. It's going to turn into a big tyrannical government. It's not going to stay small. Well, the argument back from the Federalists is, look, we're setting up a central government, but it's a limited government, very strictly limited in its powers. In fact, we're going to list out in Article 1, Section 8 of the Constitution, these are the things and the only things that Congress gets to do. If it ain't listed here, Congress doesn't get to do it. And there's, of course, a laundry list. If you look at Article 1, Section 8 of the Constitution, there's all kinds of,
enumerated powers.
And they're very specific. We get to print money, we get to declare war, we get to, do certain things. Postal service and intellectual property and some things like that. Well, one of the things, Clause 3, is the power to regulate interstate commerce among the several states. Now, what the heck were they thinking about here? Well, it's pretty clear what they were thinking about. You can look at the writings from Thomas Jefferson and some other people around this time who were writing. And here's what was happening. The various states were doing kind of what we're doing right now to other countries. They were erecting tariffs. And so could you imagine, Rhode Island erecting tariffs against Massachusetts and erecting tariffs against New York, and you're restraining trade. And one thing that the founding fathers were free traders, right? They did not want states erecting barriers against other states. And so they attempted to create a giant free trade zone. And that's what the Commerce Clause was put there for, to regulate interstate commerce among the several states, to sort of keep it flowing. In fact, I printed out Article 1, Section 8, Clause 3. The beginning starts with Congress has sort of the following powers, and here's exactly what it says, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Okay, the part we're interested in is among the several states. And regulate at that time didn't mean set up some big regulatory framework with a whole bunch of rules and regulations. What it meant at the time was to make sure it's flowing smoothly. That's what they meant by regulate. This has turned into probably the largest source of federal power. In fact, Andy, I did a little bit of research today because I knew we were making this video. And I wanted to just give people a flavor of the kinds of things that exist now because of the Commerce Clause.
And it's not just because of the Commerce Clause. Most importantly, it's because of how the Commerce Clause has been interpreted by the judges, right? All that matters at the end of the day, it's not really the writings on the page to many judges. It's their subjective feelings about how it should be interpreted, what the person in the black robe thinks that it means. And before you get into your laundry list of erosions of freedom at the hands of the Commerce Clause here, I think it's important to note, because you mentioned they attempted to make a free trade zone and limit this ability quite a bit. And for the first 120 years or so, they were pretty successful in that.
Yeah.
There were no big regulatory schemes created pointing to the Commerce Clause until in the 1930s, and we'll talk about that. But just so people can care about this and understand how much the Commerce Clause has eroded away at your freedom, what has the Commerce Clause led to?
Have you ever heard of something called the Bureau of Alcohol, Tobacco, and Firearms? We know many people watching these podcasts we're putting out really don't like the ATF. Well, thank the Commerce Clause.
That's right.
Because it's because of the Commerce Clause that we have the ATF. We also have the entire federal drug war because of the Commerce Clause. What do you think about the Department of Education, at least partially because of the Commerce Clause, and also the Internal Revenue Service, the IRS? They do lots of things based on the Commerce Clause. Think about the Departments of Commerce. The entire Department of Commerce exists because of the Commerce Clause. The Department of Transportation, the Department of Labor, the FTC, Federal Trade Commission, only because of the Commerce Clause. The SEC, Securities and Exchange. The EPA, Environmental Protection Agency. The USDA. The FCC. The FDA. The NLRB. All civil rights legislation. The consumer product safety stuff. All of it comes from the Commerce Clause.
We could pause on any one of those things and just talk about how they lead to erosions of freedom and have led to massive infringements on our freedom. And the fact that all of that comes from this very, very simple clause, which is, hey, states, play nice and don't tariff each other and make sure that you're trading with each other, has led to that laundry list.
Yeah, and one thing that's interesting to really understand this, I mean, have you ever wondered, we have this big, huge federal drug war, but alcohol is the same way, right? And they didn't just sort of create a war on alcohol, right? Because at the time when alcohol prohibition came up in our country, nobody thought that the federal government had the power to regulate alcohol, at least the purchase and sale and manufacture of alcohol. It didn't cross anybody's mind that you could use the Commerce Clause to regulate alcohol on the federal level. And that's why in 1919 we get the 18th Amendment. Why do we get an amendment here? Because nobody believed that the federal government, specifically Congress, had the authority based on the Commerce Clause or anything else to regulate the purchase, sale, manufacture of alcohol. And of course, we know how that turned out. Not that many years later, in 1933, people in the country realized, well, that was a huge disaster, so they repealed the 18th Amendment with the 21st Amendment. But why do I bring this up? I bring this up because as late as 1933, legislators in our country didn't think they could just pass stuff and regulate things and cite Congress's power listed in Article 1, Section 8 as the reason they can start regulating things. Well, boy, has that changed. We didn't get a constitutional amendment to regulate marijuana or to regulate firearms, because by the time those regulations came up, it was pretty well understood, really as a result of FDR, right? Franklin Roosevelt, that president who created the New Deal. The New Deal was your deal with government. It was going to be a gigantic social scheme. We're going to take care of you now from cradle to grave. Forget about all this stuff about government being your agent, protecting your rights. Your New Deal with the government is government's going to take care of you from cradle to grave. Mm-hmm. That's when the Commerce Clause started getting expanded. And really, for people to understand the Commerce Clause, there's really three areas that is widely understood now that Congress can cite the Commerce Clause and regulate. Area number one is what we call channels of interstate commerce. This is stuff like the roadways, the highways, airplanes, airports. Those things are in interstate commerce. They, by their very nature, they exist to serve interstate commerce. Then there are persons or things that are currently in interstate commerce. And then the final category is activities that, and here's the language, substantially affect, end quote, interstate commerce. And of course, there's greater deference, because we've had some cases recently, greater deference for purely economic activity. If it's purely economic, then it's more likely to be in commerce. If it's non-economic or criminal activity, well, then there's at least an argument that it doesn't fall into commerce. But, for people to understand what happened here, you really got to understand my least favorite case, Wickard versus Filburn.
Yeah, that's really when the top blew off of all of this stuff. Wickard v. Filburn made a new rule, basically, and reinterpreted the traditional understanding of the Commerce Clause, because it was in that case that they said, you know what? We've decided our interpretation of the Commerce Clause is that the federal government can regulate fully intrastate commerce, in other words, stuff that just occurs right within that state, if in mass it would have an effect on the greater scheme of commerce. So, they really stretched this thing far. You could have something, in that case, it was wheat that was solely grown in that state.
Yeah, think about what's going on here. You got Farmer Filburn. And he's growing wheat on his own property. He's not selling it. He's not shipping it off his property. And he's feeding his own animals with the wheat. He's using it on his farm. And here comes this big, huge federal program called the Agricultural Adjustment Act, and it applies to Farmer Filburn. Filburn says, how does this thing apply to me? I'm not in interstate commerce. I'm just growing the stuff on my property. It's not for sale. It doesn't even leave my farm. Well, it gets up to the United States Supreme Court, and then in this landmark decision, what they say essentially is, look, we know Farmer Filburn, he's not selling his wheat in interstate commerce. We're not even making that argument. Nobody's claiming that. But, if we look at what Filburn's doing, he's not the only guy doing this. There are other farms out there that are also growing their own wheat. And if you take the cumulative effects of what Farmer Filburn and all these other farmers are doing, they're not purchasing wheat on the open market. And that lowering of the demand on the open market for wheat, that affects the interstate price of wheat on the open market. And that's enough of a connection to interstate commerce to satisfy the requirement that Congress regulates interstate commerce activities here. So Farmer Filburn, you got to apply with the Agricultural Adjustment Act.
So people are probably wondering, okay, so it's a case about wheat and growing wheat. How does that lead to the ATF? How does that lead to the drug war? How does that lead to criminalization, jurisdiction for pretty much any crime you could think of under the federal criminal system? And you can really see this flesh out in the decades to come. The most recent example of this is the Raich case. The Raich case is a case where somebody was growing marijuana in California, just in the state. It wasn't traveling outside. But
in accordance with California law at the time.
In accordance with California law. Well, the feds had a different law about
and these
marijuana.
People growing it had terminal cancer, were growing it in their backyard, using it in their homes to smoke, perfectly legal under California law, but still illegal under federal law.
Yeah, and so the feds decided that they had jurisdiction under the Commerce Clause to come in and charge these people with federal crimes. And it all went back to that wheat case, right? They were saying, well, you know, in the aggregate, this could travel outside of the state, and they're not the only people growing marijuana here. So even though there's no evidence whatsoever that it's crossing state lines, we are trying to bring the Commerce Clause in. And, you know, we've decided, the federal court has decided that they have jurisdiction to criminalize this act.
So same thing happens with firearms, right? Same thing. What they've said is, look, if the firearm is sort of manufactured in your state and it's never left your state, okay, fine. The federal government doesn't have jurisdiction. But if the firearm has crossed state lines at any time, right? So imagine a firearm that's made in state A. It crosses state lines to state B. Someone buys it in state B and then sells it to another person who sells it to another person who sells it to another person. And then it sits in their basement for 20 years. And let's just say it's a federal crime to have such a weapon, like say it's a machine gun. And the federal government says we're using our powers under the Commerce Clause to make a law that says no machine guns. And somebody gets charged with that crime and makes the claim, wait a second, that firearm, that fully automatic machine gun, that's not traveling in interstate commerce, and I, therefore, shouldn't be subject to that federal regulation. Well, that just happened in a case in the 10th Circuit. And so in the U.S. versus Tamori Morgan case, this is a case where Mr. Morgan, in the 10th Circuit, he's charged with the federal crime of possession of a machine gun, actually 2 counts, possession of a machine gun, violating federal law based on the Commerce Clause. And he goes to court, and he's got a public defender, and a very sharp one, I should say. And that federal public defender makes 2 different arguments in a motion to dismiss. Argument number 1, this thing violates the Commerce Clause. Gets us really excited, right? This violates the Commerce Clause. Mr. Morgan, he's not doing anything in interstate commerce. This thing moved through interstate commerce many, many years ago. It's been sitting in his room or in his house for a long time. He is completely unconnected to interstate commerce, and the federal government, therefore, has no right to regulate his firearm. Very good argument, in my opinion.
Absolutely.
And then the second argument, by the way, this violates the Second Amendment under Bruin. Another excellent argument, in my opinion. And he hits the lottery, the criminal defense lottery, right? Because a judge in the district court in Kansas grants that motion to dismiss on Second Amendment grounds and says, you know, as I analyze Bruin, I'm going to go back and do what's called a historical analysis, just like Bruin says you do. In fact, Bruin makes the point, it's not just for the Second Amendment. Also for the First Amendment, we do a historical analysis. And the Sixth Amendment, we do a historical analysis. So when we do a historical analysis under the Second Amendment, we can't find an old analog that existed way back when, where the government was able to tell people that they couldn't have machine guns, and therefore this violates the Second Amendment. I'm going to dismiss the case. And as to the Commerce Clause argument, well, that's moot now, so I'm not going to rule on that argument. case dismissed.
Yeah, this is a very common thing. If the courts see an easier way to resolve an issue, then they'll pick that issue and just not get to the other issues. They'll rule them moot, right? So without reaching the question of whether this was a Commerce Clause violation, court said, I'm satisfied with the violation of the Second Amendment argument. I'm satisfied with the Bruin argument, with the historical analysis. Case dismissed. Well, the government wasn't happy about that, and they filed an appeal. The government has appealed this decision to the 10th Circuit Court of Appeals, and they are challenging the dismissal on Bruin grounds. So right now, both sides are in the process of filing their briefs and getting ready to fight this one out.
Yeah, and this one is still pending as we're recording this video. So enter the Attorneys on Retainer Association. You know, people who have watched our recent updates know that, we had a whole pile of different updates in there. One of those things that we probably went by really fast was this legal advocacy benefit. We didn't really spend a lot of time talking about that. I think we probably said, hey, we're really excited about this. It's going to be great. And we moved on. We're talking about, the civil liability and the red flag and all the other great stuff out there that people were really clamoring. But deep down inside, me and you were really excited.
One of my favorite parts of the new association.
Because what this means is everybody who has signed up in the Attorneys on Retainer program, who is now a member of the Attorneys on Retainer Association, and that's everybody who's been in the program. Everybody who joins the program now is an affiliate of the Attorneys on Retainer Association. Well, a portion of those monthly dues that people pay, or yearly dues, we take that and we kind of put that off to the side and we say, you know what? This is the Marc and Andy Fund to go out there and wreak havoc on as many pro-freedom issues and file briefs and go crazy on stuff as much as we want. And we're going to go right for the throat on this stuff. I mean, imagine if this Commerce Clause argument wins and that big laundry list of stuff that I just listed where, I don't know how big we win, but imagine we win big and all that laundry list of stuff now becomes unconstitutional, or said more precisely, beyond the jurisdiction of Congress to regulate.
Yes, and we're not of the illusion that one bullet is going to end this war. This is the first shot that's fired. Our project here with the Commerce Clause is going to be to get people talking about it. I want to file it in a whole bunch of different cases. And also, you and I are going to be working on a law review article soon, which we're hoping to get published later this year, trying to get people to have this conversation. What was the original purpose of the Commerce Clause? And how has it been bastardized over the years as a vehicle for eroding people's freedoms? And I got to tell you, Mark, this current configuration of the Supreme Court might just have the balls to return to the original interpretation of the Commerce Clause. I think we've never been better situated to get this type of a favorable ruling before.
There's no question. In the entire history of our country since the big expansion of the Commerce Clause, this is probably the first time ever we've had an opportunity to bring such arguments. And this really goes right for the throat here. And so if we're able to get this law review article published, this will be sort of the intellectual argument, right? We can cite that in our briefs when we file them, which of course are limited, right? There's only so many pages you can file in an appellate brief. But if we can then drop a footnote and say, check out this law review article, we can lay out the entire historical analysis of the Commerce Clause and make the case that the Commerce Clause was just not intended to be some big grant of power to Congress to regulate everything and anything under the stars. This was just supposed to be the ability to make us a free trade zone. And so now we've filed this amicus brief. In this case, I have it in my hand, and we will link to it in this video, and I hope people will take a peek at it.
Let's explain what an amicus brief is. So an amicus brief is when a party who is not involved directly in the matter wants to file something to give the court some more information, maybe share an opinion or give some legal precedent or make an argument that they would like the court to consider. And you need consent from the parties in a case to file an amicus brief. We got that in this case, and we filed it. Now, keep in mind at this point, we filed the amicus brief. The court has it in their hand. They're going to be considering it. But at this point, the Commerce Clause argument has been ruled at the lower trial level court to be moot, okay? And so all that's on appeal right now that the government is able to challenge, what's active in play right now on the appeal, is the Bruin argument, the Second Amendment argument. But that's the point of our amicus brief. We want to say, hey, appellate judges, yes, we agree with the Bruin analysis and we believe it was properly dismissed, but here's some things we'd like you to consider. We think that the Commerce Clause argument was totally valid when raised by the public defender in this case, and here's the reasons why. And we give some additional arguments that they didn't cover in their particular brief to supplement and add to it and give some more context and arguments.
Yeah, there's judges out there who understand what we just said about the Commerce Clause and who are also very unhappy about what's happened with the Commerce Clause. There are some pro-freedom judges out there. So we're kind of throwing out a line, baited up really nice, and maybe one of those judges on the 10th Circuit Court of Appeals will write something, either a concurring opinion or maybe a dissenting opinion, depending on how this appeal goes, and say, by the way, there is this other argument. They may remand it or something like that. They could even remand it with instructions to consider the Commerce Clause argument, or maybe even just a line that says, there was an issue brought up under the Commerce Clause. This is a serious issue. We should do a historical analysis. That would be great, because now that signals to other lawyers in other cases, hey, there's some blood in the water out here. Cite that opinion, cite that language, and file another brief. And wouldn't you know, we're loading up another one.
This is how you make wide-sweeping change. You got to fight the fight in as many applicable cases as you can, and sometimes you're going to win. And if you can get one victory here, other people can point to that ruling as a persuasive authority and start making more change. Also, changing hearts and minds, and that's what the law review article is all about. But just filing these amicus briefs, we're hoping that we start to see more defense attorneys get more courageous and file these types of arguments.
Yeah, pro-freedom attorneys who are really in the thick of it, who understand what's happened in our country, recognize that really, if you were going to point to something, it's the expansion of the Commerce Clause that has done more damage to the concept of a limited federal government with specifically delegated limited powers probably than anything else.
My pitch of this video should have been, we are fighting the single thing most responsible for eroding freedoms of Americans in America today.
Yeah, I think that's not an overstatement.
That is not an overstatement.
Right, that is not. You've said it really accurately. And so if you're watching this video and you're finding out for the first time about the Commerce Clause, you may take a peek, get on the internet and find out what happened with the Commerce Clause. You'll see what we're talking about. So very proud to say that the Attorneys on Retainer Association has now filed its very first amicus brief, titled under the name of the Attorneys on Retainer Association, funded by the people who have joined the AOR program. And we will continue to fight these fights. We're planning to bring another one in the 11th Circuit here soon. We're working on another brief. Hopefully we can argue it. In fact, we've made some calls over there to say, hey, can we get some time, to the lawyer who is fighting that case? Would you mind giving us a few minutes so we can show up in the 11th Circuit Court of Appeals and make an argument that this Commerce Clause thing is absolutely out of control, and see if we can get a judge or two or three to kind of bite on that argument? Because the ultimate goal is to fight this thing all the way up to the United States Supreme Court. That's where the change actually needs to happen. And the limitation of the court is they can only rule on things that are in front of them. And if nobody brings these kinds of cases before the Supreme Court, then they don't have an opportunity to say, you know what, we made mistakes and we're going to change those. We're going to overrule Wickard versus Filburn. We're going to overrule all of those cases that expanded the jurisdiction of Congress to literally regulate almost anything that they want under the sun, and now really take a hacksaw to the government and the government's programs and chop this thing back down to what was intended by the Founding Fathers when they really voted on the Constitution, which was that it's not that this stuff can't be regulated at all, but it's not a federal level regulation. It's a state level regulation. And, a lot of states may choose not to regulate in these areas and let the free market do its thing.
Yeah, I think there's a really important way that we can help people understand why this plan of attack is so important. Because right now, what's going on in the Trump administration is there's an executive attack on the government, on the federal government, an executive power working on scaling it back. This is just the equivalent in the judicial branch is what we're trying to do.
Right.
We're trying to go for the thing that is the source of so much control in people's lives. And I'm sure that we probably have subscribers who maybe just have pet issues, right? Like, for example, do you not like the ATF? Do you not like the Department of Education? Pick your poison from the list of letters that you spouted off there. It's all based on the Commerce Clause. And so whatever it is on this list you don't like, if we go for the throat, we can make huge societal change.
That's what we're doing with your money. If you've joined up for the Attorneys on Retainer program, that's what we're doing with your money. We are doing what we like to do, which is to fight for freedom. That's why our firm is named the Attorneys for Freedom, and very proudly so.
Yeah, this is like a dream job for us, Mark. And I make no bones about it. Because of our association members funding these things and us using a portion of their monthly payments to fund these fights, this is exactly what you and I want to be doing right now. These big societal battles. The association will fund a number of different cases across the United States. I kind of think of them in two categories, right? We've got kind of what we're up to here, the big sweeping ideas, the big societal changes that make a huge impact over many different areas of people's lives. But then we're also particularly interested in a more localized focus in terms of people who act to defend themselves who are getting railroaded by the justice system.
Yep.
So while an individual's case might not have the huge precedent-setting, sweeping effect, those are the two specific types of cases that our members' funds are going to promote.
Yeah, more specifically, we're looking for the case where somebody really did the right thing. Maybe they were a hero and they were defending another person. They acted either in defense of themselves or in defense of another person. They probably did it in an anti-gun state, and some prosecutor charged them anyway. And now they're in that unenviable position where they're staring down the barrel, if you will, of some major indictment that they can't hire a private lawyer to defend them, and they're stuck with a lawyer who might not be enthusiastic about defending them. They can't take it to trial. They can't afford experts. And, people are outraged about that. That's the kind of situation. And I hope our members will, if they hear about these, will let us know. Hey, Mark and Andy, here's a situation. Now, don't get upset if we don't take all of them. We can't take all of them, but we're going to start taking those. So that will be the sort of smaller individual type cases that we're going to do on behalf of the Attorneys on Retainer Association, but also these really big projects about trying to put the arguments in front of the Supreme Court that really would make a very big difference and get us back to what the founders of our country, the framers of the Constitution also intended, which was a government of very strictly limited federal powers, a government that derives its powers from the governed, of delegated powers. And really, the reason government exists is to protect our freedoms, not, as the New Deal tried to get us excited about, to take us from cradle to grave.
Yeah, and to go back to the beginning of this conversation, we don't need to speculate that this is exactly what the founders intended with the Commerce Clause and with the Constitution. They wrote it down. We have it all documented. If you really want to learn about the crucible, the founding of our country, I think the Federalist Papers and the Anti-Federalist Papers should be required reading. I remember back when I was in high school, we had to read a few in my government class, but I think those aren't really favored in many high schools these days. Every American should be familiar with the back and forth, the important, crucial back and forth that happened, and read the writings of Thomas Jefferson and read what the framers intended when they crafted this document. So we're not speculating that this is the actual legislative purpose of the Commerce Clause.
Yeah, so hopefully if we get that law review article published, people who are interested in this can read that and see the historical analysis of the Commerce Clause. But we're going to keep bringing these as long as we can. And so AOR, yes, it's great for training. Yes, you can make some money by telling people about it. Yes, if you get charged with a crime and you claim self-defense, we will show up like the Justice League. And our promise is we will give you a defense that no matter how much money you have, you can't get a better defense. We're going to pull out all the stops. But also, like so many of these other great organizations that we admire, Gun Owners of America and so many other organizations, they're out there trying to fight the good fight. we do that as well. That's part of what the Attorneys on Retainer Association is doing, and I couldn't be more proud about the start that we're off to right now, dropping an amicus brief in the 10th Circuit with Andy Marcantel's name on it on behalf of the Attorneys on Retainer.
This is not a modest first amicus brief, and this is not a modest first issue. We are coming in guns blazing. We've officially joined the fight in the association.
We're coming in big, and so if you're a member of AOR, thank you for being a member of AOR. You are empowering us to do the kinds of things that the Attorneys for Freedom law firm, besides defending people in criminal cases and self-defense cases, which we love doing, fighting for freedom. Hard to beat that mission.
Absolutely love doing it, man. It's a passion project for us, and your funds are in good hands, people. We're going to use them for causes that matter, so stay tuned for some additional battles coming up very soon. Can't wait to talk about it, man. All right, everybody, go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you. Also, check out attorneysforfreedom.com to learn all about our law firm and how we defend people in the criminal justice system. Until next time, this has been attorneys Andy Marcantel and Marc J. Victor signing out.
Peace.